Hello, my name is Annebelle Klein, and I am a research associate at the Marine Affairs Institute and Rhode Island Sea Grant Legal Program. Today, I will be presenting on the responsibility for removing abandoned and/or uninhabited coastal structures in Rhode Island. This presentation is provided only for informational and educational purposes and is not legal advice. This presentation will provide you with an in-depth examination of the various laws that may be used to determine the responsibility for removing abandoned coastal structures in Rhode Island, as well as the state's current laws governing property abandonment. In addition, this presentation will examine several potential solutions for managing shifting property lines and avoiding coastal property abandonment. This presentation was created in response to questions from the Rhode Island Climate Resilience Learning Network's foundational group. The report has been made available to the foundational group, and it can also be found on the Marine Affairs Institute's website. As sea level rise, erosion, flooding, and increased storm intensity leads to more vulnerability of infrastructure along Rhode Island's coastline, several concerns have been raised, including those regarding the responsibilities of private property owners, municipalities, and the state in managing the relocation or destruction of vulnerable properties in the coastal zone, specifically those in high-hazard areas. In response to these concerns, this presentation will 1. Examine the various laws that may be used to determine the responsibility for removing abandoned coastal structures in Rhode Island, as well as the state's current laws governing property abandonment. And 2. Analyze several potential solutions for managing shifting property lines and avoiding coastal property abandonment. Ultimately, by the end of this presentation, you should be able to 1. Recognize how a property owner's responsibility for removing abandoned coastal structures in Rhode Island is determined and what that entails, and 2. Assess the feasibility of potential solutions for managing shifting property lines and avoiding coastal property abandonment in the state. So, what's the big deal? Why have several concerns been raised regarding the responsibilities of private property owners, municipalities, and the state in managing the relocation or destruction of vulnerable properties in Rhode Island's coastal zone? The photo on this slide, which depicts the aftermath of Hurricane Sandy on Roy Carpenter's Beach in South Kingstown, Rhode Island, helps demonstrate that sea level rise, erosion, flooding, and increased storm intensity is threatening Rhode Island's coastal infrastructure. As the effects of these threats worsen, consequently, coastal structures in the state are likely to be abandoned and/or left uninhabited. Notably, however, abandoning the coastal structure may not always relieve the property owner of his, her, or their responsibility to either relocate or remove the structure. In Rhode Island, the responsibility for relocating or destroying abandoned or uninhabited structures along the state's coastline ultimately falls on the party that owns the realty. So, before any liability for removing or destroying the coastal structure can be assigned, property ownership must be determined. In Rhode Island, the public trust doctrine is used to determine property ownership along the state's coastline. The state maintains the title to most of the coastal land that is situated below the public trust line, which is located at up to 10 feet landward of the visible high tide line. And private property owners of abutting coastal land maintain the title to all coastal land that sits shoreward of the visible high tide line. Importantly, most states, including Rhode Island, recognize that instances of accretion or erosion automatically leads to changes in the property line, and the loss of coastal land caused by avulsion generally does not lead to there being any changes in the property line. Thus, Rhode Island's public trust line has the potential to shift depending on the type of shoreline change that occurs. Ultimately, given that the public trust doctrine is used in Rhode Island to determine property ownership along the state's coastline, and that property ownership must be determined prior to assigning any liability for the removal or destruction of an abandoned or uninhabited coastal structure, determining whether the public trust line has shifted is pertinent. The Abandoned Property Act governs property abandonment in Rhode Island. The Act provides that property owners of coastal structures may be required to either correct any allegedly abandoned structure's dangerous or unsafe condition or eliminate the structure's violations of the Rhode Island State Building Code. The property owner will be deemed liable for all costs associated with correcting the structure's condition or remedying the code violations. If a court determines that the coastal structure has been abandoned and left in either a dangerous or unsafe condition or has violated the code and constitutes a public nuisance that the property owner has either refused or failed to correct, then the court shall order the necessary parties to show cause why a receiver should not be appointed to perform any work and to furnish any material that reasonably may be required to abate the public nuisance. A receiver will only be appointed to abate the public nuisance in select circumstances, and the property owner will be deemed liable for the costs associated with abating the public nuisance. Lastly, the Act also provides how interested parties can request that a coastal structure be demolished, so long as the requesting parties have paid the costs of demolition and of the receivership, and all notes, certificates, and mortgages of the receivership. Overall, these provisions of the state's Abandoned Property Act make clear that the responsibility for relocating or destroying an abandoned or uninhabited coastal structure in Rhode Island will most likely fall on the property owner, unless it is another party that requests the demolition of the coastal structure. There are several laws governing obstructions to navigation in Rhode Island that may be applicable to the issue of property abandonment in the state. The Rhode Island Department of Environmental Management, RIDEM, has both the responsibility and power to remove any unlawful or unauthorized structure deposited or suffered to be or remain in the tidewaters of the state, and is or is liable to cause or become an obstruction to the safe and convenient use of the waters for navigation and other lawful purposes. Upon learning the owner of the unlawful or unauthorized obstruction's identity, the director of RIDEM must notify the obstruction's owner to remove it within a specified time period. The owner will be deemed liable for all costs associated with removing the obstruction. In instances where the obstruction's owner is unknown and the obstruction has not been removed to an acceptable place in a sufficient manner by the specified time and/or date in RIDEM's notice, or is likely to sink, break up, or pose a threat to navigation, or has already sunk or broken up, or constitutes an immediate danger to the general welfare, the director of RIDEM or another authorized public entity may proceed to remove the obstruction, or to complete the removal thereof, or to cause the removal to be done in such manner and to such place as the director of RIDEM or other authorized public entity shall deem best. The obstruction's owner will be deemed liable for the costs associated with removing the obstruction. Should the obstruction's owner fail to pay for its removal, the removal will be paid for from either the derelict and abandoned vessel and obstruction removal account or the Treasury of State's appropriated funds. However, in this case, the owner must repay any costs and/or expenses. Ultimately, these laws governing obstructions to navigation in Rhode Island make clear that the responsibility for removing an obstruction, an abandoned or uninhabited coastal structure in the state, falls on the obstruction's owner. Considering how a determination of property ownership will place the responsibility for relocating, rehabilitating, or demolishing an abandoned or uninhabited coastal structure onto most likely the property owner, as well as the costs of relocating, rehabilitating, or demolishing said structure, it is important for the Rhode Island Climate Resilience Learning Network to understand that there are several tactics that can be used for purposes of managing shifting property lines and avoiding coastal property abandonment. First, requiring coastal property owners to obtain a permit that mandates the removal of the structure when the sea rises to a certain level is one tactic that can be used for purposes of managing shifting property lines and avoiding coastal property abandonment. Pursuant to the Coastal Zone Management Act, the CZMA, coastal states will generally limit a littoral landowner's ability to develop their property via the issuance of a permit, and there are several coastal building permits in existence that require the property owner to remove the structure when the sea level rises to a certain point. Notably, these types of building permits do present challenges under the United States Constitution's Takings Clause. However, in at least one coastal state, this type of building permit has been found not to be a regulatory taking. Ultimately, if the Rhode Island Coastal Resources Management Council were to require this type of coastal building permit in the future for new builds in the state, then the inclusion of a provision mandating a coastal structure's removal when the sea rises to a certain level would relieve the state from bearing any costs associated with the relocation, rehabilitation, or demolition of an abandoned or uninhabited coastal structure. Thus, by placing the responsibility to relocate, rehabilitate, or demolish the coastal structure onto the littoral landowner, the coastal building permit would likely dissuade littoral landowners from abandoning their property altogether. Second, requiring coastal property owners to obtain a permit that mandates financial assurances is another tactic that can be used for purposes of managing shifting property lines and avoiding coastal property abandonment. Pursuant to the CZMA, some coastal states may opt to protect their coastlines by including a financial assurance provision in the relevant coastal building permit, which would require the littoral landowner to prove that they can cover the costs of potential damage caused by any development on their land. Similar to the other type of coastal building permit, this type of permit also presents challenges under the takings clause. However, this type of building permit has also notably survived a takings challenge in at least one coastal state. Ultimately, the inclusion of a financial assurance provision in a coastal building permit could help states protect themselves from being left with the full costs of any inundation-related cleanup. And if the Rhode Island Coastal Resources Management Council were to require this type of building permit in the future, then the inclusion of a provision mandating financial assurances would likely dissuade littoral landowners from choosing to build in the coastal zone and abandoning their property altogether. Overall, as this presentation has explained, the responsibility for removing an abandoned coastal structure in Rhode Island will likely fall on the structure's property owner. Due to the public trust line's ability to shift, the property owner can either be the state or the owner of abutting coastal land. Importantly, however, there are several tactics that can be used to manage shifting property lines and avoid coastal property abandonment in Rhode Island. So, what are the next steps? What more can interested parties do as it relates to the responsibilities of private property owners in the state and managing the relocation or destruction of abandoned properties along Rhode Island's coastline? For starters, all those that are interested in joining the conversation surrounding this issue are encouraged to join the Rhode Island Climate Resilience Learning Network. Moreover, accessing a copy of this presentation's accompanying report, which can be found on the Marine Affairs Institute's website, will provide more details and knowledge on this particular topic. Thank you.